Good morning, and welcome to Radcliffe Talks Real Estate. This is a series of webinars that started back in the spring of 2020, in those days of lockdown, where a member of Radcliffe Chambers invites a property practitioner to talk about something that's topical in the built environment. And I'm delighted to welcome Jerome Webb today from Gordon Ingram Associates to Actionable Infringement of Rights to Light, what developers and objectors need to know. Jerome is a senior equity partner at Gordon Ingram Associates, a market-leading chartered surveyors practice with several offices, but centred in London. And he not only does he work with the RICS on guidance and standards, but he was the rights to light expert in the most recent reported case, the Beaumont and Florala decision, in which his expert opinion evidence was accepted by the judge. And we'll touch upon that case in due course. So the talk is going to be in 6 parts, Jerome. We've got what is a right to light, how is a right to light acquired, how is a right to light lost or extinguished, what constitutes an actionable infringement, what is the cause of action, and what are the likely remedies. We'll leave a slot for a few minutes for questions at the end. People could put in questions in the Q&A session towards the end of the talk. Hopefully we'll try and answer them. If there isn't enough time, both Jerome and I are willing to receive emails and answer questions independently outside of the webinar. Thank you for that, Jerome. So just before we get on to what is a right to light, there were 2 predicates in the flyer. One, that rights to light litigation or disputes are perhaps increasing, and secondly, that the insurer's appetite may be slightly diminishing, taking on indemnifying the risk. Would that be your?
I think, I think those 2 trends are notable in the marketplace.
Yes.
And they are linked.
Yes. Good. And hopefully we will cover both subjects that are of interest to real estate transactional lawyers, as well as those that deal with dispute resolution. So in terms of what is a right to light, of course, it's an easement. Real and repart, 4 essential characteristics apply. I don't think I need to repeat what they are. It's a negative right, and it's the right to the light received by a building, the dominant tenement. That slide, hopefully you can see a dominant tenement there. Not over vacant or garden land, but to another building, which is the servient tenement. And it's the right to receive light through windows or apertures, known as ancient lights. It's a private law right, not to be mixed up with planning, daylight and sunlight, natural material, which are material considerations of planning application. Jerome, do you think there's much mixing of the concepts, do you see, in practice, or are people reasonably clear on that divide?
Most people are pretty clear on the divide, but certainly the lay participants in the planning process sometimes get confused between the 2.
Right.
But it is always very important to be clear what the distinction is at the outset of a project to ensure clients and the client team are clear as the difference.
Thank you. So turning to the second topic, how is a right to light acquired? We've got, of course, an express grant or reservation, and that may be a conveyance, a lease, a deed. Jerome, how much of your work involves consideration of property deeds, looking for relevant provisions?
It's a key part of the due diligence work which we tend to undertake at the early stage, because obviously part of the exercise which we go through is to determine which buildings around our client's property may enjoy a right to light.
Yes.
So an initial look at title, just to see if there are any rights to light deeds registered, and if so, an initial look to see whether they might be relevant in respect of our client's development site or our client's adjoining owner property, if we're acting for the adjoining owner. And then, of course, we pass that on to our legal colleagues to give a more detailed legal view as to the precise meaning of that deed.
Thank you. We've got, of course, one mustn't forget implied grant or reservation. It's a bit more subtle. Section 62, Law of Property Act, the rule in Weald boroughs, or even non-derogation from grant. I think prescription, and this perhaps is one of the complicating factors, of course, there are three methods of prescriptive acquisition of the easement. At common law since time immemorial, pretty rarely encountered, 1189, I suspect. Lost modern grant, which came about because it was too difficult to acquire purely at common law, and then under the Prescription Act, 1832, so it's nearly 200 years old. 20 years immediately before the action, the use need not be as of right. This is important, it can include leaseholders, of course, not against the Crown. Jerome, this is the most common, is it not? Area in which one encounters the acquisition of a right to light.
Yes, in the day-to-day business of dealing with rights to light and development, it is usually the Prescription Act which we rely upon, is relied upon. As has been mentioned, you know, the express and implied grants, we'll see that also is quite common where you have titles being split, and development taking place on that, and understanding those grants is a critical part of establishing whether rights do or do not exist between two principal neighbours.
Yes.
So that is also quite a common theme, but other than that, prescription is the primary route by which we tend to find rights are enforced or pursued.
Section 3, enjoyed for the full period of 20 years. Now, Jerome, this is an important topic and something that's quite elusive that, of course, and perhaps trap the unwary that just because a building's less than 20 years old, there is this transference of rights concept. I think you've got some slides which show this point very well. Perhaps you could just explain how that slightly elusive concept works.
Of course. So if a building has acquired a prescriptive right to light through its apertures, and it is then subsequently demolished and replaced with a new building.
Yes.
The simple principle is that if there is substantial coincidence between the old windows of the building demolished, which had the prescribed rights, and the new building, and that there was an intent, I think is important to demonstrate that the light should be enjoyed to the new building, the same way that was enjoyed by the old building, then that prescribed right can be enjoyed by the new building. So the nuance in that is that even if the building demolished, although this is quite uncommon, is under 20 years old, but the windows are in a very similar place in the new building. Say the building's been up for 10 years and it's demolished and a new building goes up.
Yes.
New building, after 10 years of being in place, would have 20 years of continuous light. So you could take 10 years from the old building and the 10 years add them together. So that's a little nuance. But what the image on the screen is showing, everyone can see that, is obviously that is a pre-existing building. So the one which has been demolished and is being replaced by a more modern building, which we call the existing building as it's existing today. And then what we do as surveyors is try to understand which of those windows, which are shown there from the existing building, correlate and match with the windows of the demolished building. And as you can see, we've overlaid two elevations, and you can see in the orange where there is an overlap of the old window to the new window. And that's more particularly shown on this drawing, where you see exactly on the new facade of the new building,
Yes.
where the transference of light from the old windows to the new would exist. Now you'll see some of those windows they've got a very high degree of coverage, i.e. there's a lot of orange of the old window matching the new window, and others where there's only a very small proportion. But as a general look at that elevation, you'd say there's a high degree of coincidence between the old and new windows. And as such, there's clear transference to that building.
I think one could describe that as a pitfall for the unwary. Would that be fair?
It is, because quite often people just look at it and say, oh, the building next door is new, it's only been up for 5 years, I don't need to worry about rights of light, it hasn't got any yet. But yes, no.
Thank you. Interruption. Section 4 of the Prescription Act. 1 year after a party interrupted shall have had or shall have notice thereof. And that, jumping about slightly, takes us to light obstruction notices under the 1959 Act. How frequently is that a topic that comes into your world?
Well, abandonment in itself is a complex area.
Yes.
In terms of easement, abandonment of easement.
Yeah.
So I think it's an area just to always proceed with caution as to whether or not historic rights have been abandoned.
Yes. We've got a nice picture there of an old mill or something like that.
Yes, where partially demolished and partially not demolished.
Yes.
And therefore has the demolished area abandoned its rights or not?
Yeah.
Fact and degree matters which are very specific to the individual case.
Yes.
Come into play on that. With regards to the light obstruction notices, obviously it's the 1959 Act, which
Yes.
you mentioned, came into play, not long after the end of the Second World War. A lot of London being derelict due to bomb damage and
Yes.
need to preserve the development position and prevent adjoining buildings acquiring rights.
Yes.
So the concept of a notional obstruction was created, so you don't
Yes.
have to physically put up an
No.
obstruction to block.
Makes life a bit easier.
Make life a bit easier.
Yes.
So this is a concept where you effectively serve notice on your neighbour to say, please be aware there is now a screen
Yes.
which sits on my land, either of unlimited height or to a specific height or
Yes.
profile, which is blocking your light. And that refers back to the part in the Prescription Act where you acquire your right
Yes.
20 years continuous enjoyment.
Yes.
Unless there's been an interruption for a 1 year period.
Return to section 4 of the Prescription Act.
Exactly.
Yeah.
So the notice has to stand for a year, and so long as the adjoining property has not at that point already acquired rights by some means, that notice will then effectively reset the clock back
Yes.
to 0, and you can keep serving that notice.
Interesting.
Prevent it from acquiring rights.
Interesting. I think, and one of your takeaway points, we did say that whilst the talk's generally introductory, there'll be something for the very seasoned practitioner. I think you've got quite a knotty point in relation to limitation, but I don't want to spoil the surprise. Just I've slightly jumped around a little bit, but those notices, I believe, they're dealt with by the tribunal, I think. But the land registry, there's been some migration from local land charges searches to HM Land Registry, I believe. So you've got to make sure you search in the right place, obviously, to track down these notices. So just dealing with other ways the right to light may be lost. we've looked at abandonment, unity of ownership, obviously not to be forgotten, because the fundamental point of an easement, you can't have one if there's unity of ownership under Reander Park. By agreement, the deed of release, section 53 of the Law of Property Act 1925, and getting the document right for section 2, Law of Property Act, miscellaneous provisions purposes. Jerome, I just wanted to touch upon statute and what was section 237 of the Town and Country Planning Act 1990, power to override easements and other rights, and the mystery of the Barbers case decided by Mr. Justice Dyson, as he then was in the mid-90s. And we've now got sections 203 to 6 of the Housing and Planning Act. How well versed are, in your experience, the City Corporation, for example, and other central London authorities in utilising this override power? I was always going to say get out of jail card, but how does that work in practice?
I mean, my view is it's an extremely important part and function of delivering development in a complex city environment. And that's obviously why these provisions are there in the Act. Because, as we all know who work in the property field and development field, securing planning consent, particularly for a major scheme, is a time-consuming, highly expensive process. And it involves an awful lot of consultation with stakeholders, and rightly so, and a lot of engagement with the local authority, both at officer level and council level, to reach that point where a decision, hopefully a consent, is granted. But as planning does not deal with rights of light, as you mentioned, and rights of light being a private easement matter, just that because planning has been granted does not mean that there aren't rights of light issues which are yet to be resolved. Now, as always hoped, and in a large degree is the case in practice, that where rights of light infringements do exist as a result of that planning consent, those do get resolved through either the design process and how the development forms in the development of the scheme.
Maybe some cutting back
or moving the mass to minimise those risks or remove them wherever possible. It isn't entirely possible to get rid of all of them in all cases.
No.
But those then tend to be resolved through negotiation, and a neighbourly settlement is arrived at with the neighbour to allow the development to proceed. But should you arrive in a situation where that is just not possible, either because the neighbour just says, well, no, I have an absolute right to my light, and I want my light, and I'm not interested in any amount of money to give up my light for whatever reason, which is it's entirely their right to make that position. That's their legal right. But at the same time, particularly in the city, for example, they take a view that if they have worked closely with an applicant to give a consent for a major scheme in the city, which they genuinely believe is important for the not only national but international importance of the city as a financial district.
Yes.
They would not like to see that threatened or prevented from taking place because of a private right issue. And therefore, these powers exist to enable a local authority to step in and say, we will effectively take an interest in the land, appropriate the land, and in that way, whitewash over the right to an injunction risk, and therefore remove the threat against the development taking place. It doesn't remove the person's rights, and they're still entitled to some compensation, but it prevents the risk of injunction, which means the scheme can then move forward with certainty.
That's very helpful. Thank you. And I think, of course, it's important to remember that the compensation value would be on the Compulsory Purchase Act 1965 basis, as in diminution in the value of that party's interest in land. There's no question of negotiating release fees, any of that. You're restricted if those powers are exercised to that form of compensation of your interest that's been overridden.
Exactly.
Yes.
And that factor is often extremely helpful if there is an intransient negotiation or party to bring them to the table, because they may be, on the one hand, being offered inflated compensation by the developer to secure a release. Not being able to secure that release, the local authority says, we will use our powers, in which case they may be looking at a significantly reduced level of compensation. And therefore, they may be more interested in re-engaging with the discussion with the developer.
You may be holding an ace, maybe holding an ace in their top pocket.
Exactly.
Thank you. I touched upon the Midtown case. That was before the change in the codified overriding. We've looked at light obstruction notices. Covered that. Now, Jerome, actionable infringement of a right to light. So let's assume that the right to light has been acquired expressly, impliedly, or probably perhaps more likely by prescriptive right. And let's secondly assume it's not been lost. We then get to the, if you like, the nub of the question of what then constitutes an actionable infringement with one's right to receive natural light from the sun. Now, it's a question of fact, but it does involve points of law. You can have lay witnesses, ordinary person's impression, expert opinion, calculations by people such as yourself using the Waldron method or whatever it is. And that, of course, is now 100 years, pretty much 100 years since Percy Waldron did his work. Building materials have changed, structures have changed radically. And then, of course, the site view by the trial judge. Now, I think you've got some very helpful slides. Could I ask you to give your view on how this works in practice?
Indeed. So, as you say, the current basis of adequate light is what's described as the 0.2% contour, or being able to see 0.2% of the sky, which is equivalent of one candle, 1 lumen per square foot. And that was established by Percy Waldron, circa 100 years ago. This image on the screen obviously shows a standard room, and there are lots of 1 foot candles placed 1 foot apart across the room. So this room is effectively fully adequately lit by that definition.
Yes.
Now, obviously,
There's
someone reading a book, or maybe the small print of the Times, as to quote the well-known case. And obviously that is the reason why this amount of light has been considered the minimum necessary, the minimum adequate level of light, because it's sufficient for the ordinary notions of mankind, i.e. reading the small print of the Times. So that is what's set as the base level of light. That's just a close-up image of what that sort of looks like.
Yes.
Now, obviously, we don't work with candles anymore, so we do need to think about how this relates to the modern world.
Yes.
And that is a big discussion in the industry, and will, I'm sure, before long be tested in the courts. But what this process is showing here,
there's a change,
is that there has been a rule of thumb that's built up over time.
Yes.
That we don't have a right to the light, all the light that you've enjoyed. You only have right to adequate light. And as I say, that's 1 lumen per square foot. But it is in fact deemed to be only a right to have that over 50% or so of the room.
This is the so-called 50-50 rule.
50-50
rule of thumb, not a rule of thumb.
Not a rule of law. So here you are, you see persons reading there.
Yes.
Now they can continue to read in that position quite happily because they're still in the part of the room which has adequate light. So you then get a scenario where you move to the real world, and this is an existing building,
Yeah.
and obviously the obstruction outside isn't uniform, and you can see actually the contour of light
Yes.
within that room change, so that the area with adequate light now follows a more wavy line, but the person is still sat just at the point at which there's adequate. If they move their chair back a bit, they probably would find they would struggle to read,
Yeah.
and therefore that's why they've sort of placed it at that position. That's where they can see enough light to read. And then someone builds next door and it's reduced. So the person would need to now move their chair closer to the window in order to receive the same quantum of light that they had before. And so they have seen a reduction in the amount of adequate light to their room.
In the 50%.
In the 50% area.
Z?
Well, the EFZ is just the measure of the square foot.
Right.
But importantly here, it's within the 50% zone.
Yes.
So you're seeing the area which has light was already less than 50% of the room.
Yes.
And it's been made even worse.
Yeah.
So in legal terms, they have suffered a loss of their right to light. And this would therefore normally be taken as being an automatic reason for an actual injury to be sustained. However, we don't work with foot candles.
No.
And so
Natural
new
light.
radiance analysis enables us to be a bit more scientific about understanding how light is actually experienced within
Yes.
space, and then take into account more realistic information about the daylight entering the room and where it's coming from.
Yes.
Using real sky data, for example, rather than just a uniform overcast sky, which was the historic approach. So here we see exactly the same existing scenario we saw with the foot candles, but shown using grayscale render, using radiance. And then we move to the next slide, which is the proposed. And you'll see there's a slight darkening in the room.
I see that.
And the question would be, therefore, well, is that sufficient to be classed as a nuisance? Is that going to be so noticeable as to radically change the way in which that person used and enjoyed that room? If we take a more dramatic example, here we are with our foot candles or our 0.2% contour line, which people may be more familiar with. So everything which has a candle sees 0.2% or more in the sky and therefore receives 1 lumen or more of light. That bit with no candles, less, therefore inadequate light. And then we have a proposed development again, which you see quite a substantial change in it. And it looked quite dramatic when you look at it on a contour basis like this. But if we move to the radiance based, obviously a very well lit, bright room.
Yes.
Big room.
Very nice.
And in the proposed scenario, yes, it's become darker.
That's significant.
And it is very noticeable.
Or noticeable.
So again, the question then arises, well, at what point does a noticeable change become a nuisance? And or are you entitled to always enjoy that if you have a right to it? And no one can take any of it away whatsoever.
And very helpful diagrams. In terms of a few bullet points, if I may just run through them. So it's obviously not the right to all the light presently enjoyed, but it's the right to sufficient light for the comfortable use and enjoyment of the house. So we've got a residential possibility or place of business, that we've got an office scenario.
Yes.
And the complainant has the burden of proving that the premises have been rendered substantially less, as a matter of substance, they're less comfortable and convenient than before due to the reduction in the light received through the windows or the apertures. That's it, one my paraphrase. I think it's important to remember, is it not, that the bare minimum still may be an actionable interference, even if 50% remains well lit. Now, before we get on to just a few points on modern technology. Of course, in the Beaumont and Florala litigation, Florala's new apart hotel, the judge accepted your evidence in relation to diminution in value. I mean, in broad sort of headline terms, just useful just to remind ourselves that in relation to the issues in that litigation, he found one, yes, there was a prescriptive right that Bowman's had acquired to most of the windows. One or two were not, didn't benefit. Did Florala's work cause a nuisance? Yes. Touching upon busy urban environment in London, this point you've made, and about radiance and other factors, but the judge accepted that the Waldron method was still a good working tool, as it were. And there was a reduction in rental income that had been received. His third issue, if Beaumont has established a substantial nuisance, to what compensatory damages, and that's the but-for test, compensation arising as a result of the nuisance, and that in terms of rental value, that came out at £240,000. And then the fourth issue was Beaumont in principle entitled to an injunction or negotiating damages in lieu. Yes, it was entitled to an injunction, hadn't disentitled it itself, notwithstanding it hadn't got a interim injunction. And in fact, as a small point of fact, there was a rather bold stance by Florala who sought summary judgment on the basis that, because it was all predicated on trying to extract a ransom value, that summary judgment should be granted, but His Honour Judge Hodge threw out that application in 2018. And the trial judge granted the injunction, and also went on to grant negotiating damages, release fee damages assessed at £350,000, 33% release fee of the 1.1 million additional fabric that the infringing works caused. So that's just a sort of a slight aside into that piece of litigation, just to make one or two of the points. So, Jerome, can I just ask you, you touched upon candles, and we've got artificial light, we've got luminance, etc. We've got reflected light. We've also got residential and commercial uses. Can I just ask you to give your thoughts on, and you've said the industry's looking at it, and there may be a case, in fact, a couple of cases that were settled. I think some of these points were going to be raised again, but we've got no judge who's had to look at it because those two cases settled. Can I ask you for your thoughts on these areas?
Sure. I mean, artificial light, certainly in the working environment, isn't just a nice to have and an add-on. There is legal requirement that the workplace is suitably artificially lit.
Yes.
And of course, as we're discovering, as we move into the winter months, our working day will start in darkness outside and probably end in darkness outside. So in order for an office to be used as we commonly and expect it to be used, artificial light is essential.
Here we are, we've got a lovely twisty light, we've got lampshades and etc.
And plenty of natural
light.
So it plays a fundamental part in how we use our office space.
Yes.
So therefore, the question of whether the actual quantum of illumination in a room is important to us to carry out our function of doing our day-to-day work. The quantum of natural light coming in is probably less important purely from an illumination point of view than it was in the past. However, we also know, particularly through more recent research, that natural daylight isn't just about physically illuminating a task so we can see what we're doing.
Yeah.
It plays to our sense of well-being.
Yes.
It has an impact on our sense of health and our circadian rhythms and all the rest of it. And so there is a different interplay in terms of the importance of natural light within a space.
Yes.
The outcome of that discussion is nowhere near settled, and it's something which is very live and a very important point. And how much of it is just having a connection to the outside and understanding, oh, it's getting near the end of the day, it's getting dark, or the weather's changing, or just having a connection with the outside world. Imagine working in an office with no windows, but it's fully artificially lit, plenty of light to do your day-to-day task. That'd be a very different experience to one which had windows in it.
Quite a claustrophobic experience.
So clearly the window and the view to the outside has a subtle value to how we enjoy our working environment.
Yes.
In relation to residential property, I think it's very different. I think how we enjoy our homes and the importance of natural light in our homes is very different to us as people. And again, I think that has variations of importance. You know, if you starting off in life and you've got your first flat in a basement somewhere in Covent Garden, if you're lucky enough to be able to live there or wherever, you probably haven't chosen that flat because of its great natural light. It's not about that. It's about a whole lot of other things for you at that point. But as you move through life, it becomes increasingly more important. And as you may choose a property which is in a very nice area with a wonderful outlook and great natural light.
No right to a view, though, Jerome.
No right to a view, but the light is something which you may deem to be very important. And so, again, different types of residential and the different expectations and needs of the person occupying that. And that's why it's not very easy to be prescriptive about these things. You've got to look at each case very much on its own merits.
Yes.
You know, again, the nature of the occupier. You know, I had a case once where I was representing an adjoining owner who had unfortunately a bad accident and was paralysed, and their entire life lived within their flat. Right. They could get out occasionally, but not much. So the light to them was exceedingly important, far more so than another neighbour who might rarely be at home and be out a lot of the time and think, well, actually, yes, I can live with a little less light.
Yes.
So again, individual circumstances are very, very specific. I think in terms of reflected light, you touched on, difficult one. It's something which obviously exists and obviously plays a major contributing factor to the amount of light within a building.
Yes.
You can't see an external object unless there's light being reflected off it. So anything you're seeing, you could be seeing because light's being reflected from it. So it plays an important part, but legally we have no control over the external world in that regard.
That's the
And so pinning a position on where reflected light is a proportion of that becomes difficult when you're trying to assert a right or determine what is an acceptable level of light, and I've got that, but it's only because I'm getting X amount reflected light, and I can't guarantee that that's going to be there in the future.
No.
So it's a real part of the picture, but it's a difficult one to rely upon.
A related question, looking at the modern construction techniques, so much glass and steel, so it strikes one that you can look through, take a tower in Blackfriars or wherever it is. So the developer puts up a big tower, but there wasn't one before, but the light is still perhaps passing through that tower, through the windows, comes out the other side, so the neighbour still receives. How does that work, or does it not work?
It's a question we're commonly asked. What if I make it all glass and lots of light coming through to the neighbour? Unfortunately, it doesn't count for anything, because that glass they become dirty. There's no obligation on the adjoining owner to clean it. They may decide to put plants, furniture, blinds, whatever, against the glazing in due course. And therefore its translucent quality is diminished or removed completely. And therefore, as you as the adjoining owner have no ability to assert a right against that, because you have a right to direct light.
Yes, no, very helpful. Thank you. So moving on to causes of action, important to remember, of course, that it's a private nuisance. It's an interference with an easement when thinking about parties and who may be liable for a nuisance. So, of course, the defendant could have either created the nuisance, developer, could have adopted the nuisance, sail on to a freehold pension fund or whoever it is, or continued the nuisance with a possibly leasehold interest. So it's a moving theme, and just struck me thinking about let's say some overage, or let's say some community infrastructure levy payments. The overage could be triggered on a grant of planning permission, and based on prospective development, and that would then lead to community infrastructure levy having been paid based on that amount of fabric that is within the planning permission. And then suddenly, out of the woodwork comes rights to lights. Be very unwelcome, to put it mildly, because the developer has already paid the sill on a certain presumption and may have paid overage on the land triggered as a planning overage on the permission. And then lo and behold, suddenly there are difficulties about building out its scheme. So very, very important to think these things through at an early stage, it seems to me, in the development cycle.
I mean, we would always advise our clients not to trigger any such payments or liabilities until they have adequately resolved any rights of light risks which exist around their site.
Yes.
And that they need to allow time for that, because again, adjoining owners are under no obligation to give up their rights.
No.
So it's a negotiation which takes the time it takes with the neighbour.
And that perhaps may explain why we see certain sites in London where there's a permission granted and not much is happening on the land itself. It's laying vacant, and one wonders what's lying behind the scenes. Is it a delay in negotiating the Section 106 agreement, or quite what is it? But perhaps it's negotiations and
the whole strategy around how to implement those resolutions to the risk is a very important part of what we would do to advise our clients. Because obviously for them, delay is a very substantial cost in development. So, but at the same time, you don't want to be paying release fee compensation before you secured your planning, because you might not get your planning, or you may end up planning for a scheme which is smaller than what you've just done a release fee for. So trying to get the timing of the two things together, what tends to happen is obviously do all the due diligence, get all the work in place.
Yeah.
At the point where planning is about to be granted, or is granted, or resolution to grant is made.
Subject to the 106.
Subject to the 106. Now, the 106, as you say, itself may take a good few months, sometimes longer, to negotiate and get through. But the developer can, in tandem, then be proceeding with their rights of light negotiations. Twin track it. So hopefully, when their full consent arrives, they are well down the track in terms of receiving any deeds of release that they need to achieve.
How does insurance fit into the mix of that in terms of the timing of when one goes to the market? If one decides one wishes to insure, get an indemnity against potential difficulties.
Again, it's a very key part of the overall strategy. It's not always necessary, and there are different insurance policies and structures to suit different needs. But in terms of basic principles and timing, again, a lot of clients understandably don't want to be paying out an expensive premium on a policy for a scheme they haven't yet got consent for. And the insurers do tend to like, ideally, to have seen the planning application concluded, to understand what the local view is about the scheme, who's objected, on what grounds, who's come to exhibitions, who's come to public engagement exercises, what have they said, and all of that feeds into the insurer's view as to what's the potential risk here. That, coupled with our technical work and analysis, begin to put together a strategy, and that usually is a hybrid of proactive, reactive, and wait and see.
Right.
Yeah. So proactive is where we've identified people which are high risk and say, look, we need to go in, negotiate a deed of release, and remove that risk. The reactive is, we know that that's going to be probably the outcome, but we'll wait for them to come forward and knock on our door first.
Right.
And then there's the wait and see, which is usually very low risk, people who are a long way from the site, not even sure if there is an injury, but we just want to have them covered in a policy, probably very unlikely anything raised at all. So low risk, de minimis sort of injuries. And that allows the developer to get on and do what they've got to do with the knowledge that they've got insurance sitting behind them, should there be
a comfort.
Yeah.
Just whilst we're on this, what about funders? What's their attitude to the risk? I'm not talking about litigation funders. That in itself presents a whole new issue once one's into litigation. They've done, if the case is being run on a conditional fee agreement, and there's funding who got say so in the strategy tactics, what happens? But just in terms of development funding.
Development funding, I mean, the funders, naturally enough, that they're really interested about protecting their investment financially.
Yes.
So for them, the insurance product works extremely well. They just want to know that should, catastrophe arrive and an injunction be granted, which the scheme either can't then be built or has to be substantially modified.
Yes.
They're still going to get their money back.
Yeah.
So as long as there's an insurance policy in place, they're usually happy there.
Lovely, thank you. So looking at remedies, the sixth topic, don't need to worry about abatement. Declaratory relief, remedies usually in the pleading one will go for remedies in the alternative if declaratory relief is required, in the sense of has the right been acquired, has it been lost, what does the deed mean? Injunctive relief, prohibitory, mandatory. Of course, we've had the commentary on Lawrence, the Supreme Court's 2014 decision in relation to the damages in lieu question. And I think it's probably still fairly early days to say to what extent has that changed the attitude of the court. But we do know that the so-called good working rule in Shelfer has now been disapproved by the Supreme Court. Whether prima facie you're likely to get an injunction, and it's an equitable remedy, of course it depends on all the facts and circumstances, but certainly in your Beaumont case, Peter Knox, KC, sitting as a deputy, granted injunctive relief, and of course, well, the Heaney case was pre the Supreme Court, and that also, I think, where that was the case up in Leeds, where again injunction, notwithstanding the fact that the development had finished, and that again caused a real fluttering in the development world, I think. As I touched upon before briefly, there was no interim injunction applied for in Beaumont. As I said, Floral, in fact, applied for summary judgment and were not successful, and an injunction was granted at trial. In the Reagan case, slightly different. Mr. Justice Peter Smith, the judgment with the Da Vinci Code embedded in it, 2007 interim injunction, but no final injunction in that particular case. So turning to damages, we've got negotiating damages, and we've got the Morris Garner Supreme Court case in 2019. I think some commentators will say it rewrote the law on this topic. That was all about some shares in care homes in Thames Valley and covenants not to compete. But it's a Supreme Court case, it's the leading authority. So it's a question of range, whether you call it root and park damages, 5%, whether you call it hypothetical bargain, whether you call it reasonable license fee damages. I think the range is between 5 and 40%, judgment for 33% in Beaumont. What's your, I appreciate you're not a lawyer, what's your view on how these things are playing out? Do you think people are there trying to extort money?
I think at this moment in time, we have seen a rise in people using litigation as a means to put excessive pressure on the party developing in the not unrealistic expectation that that will result in a higher payout. And that does seem to bear fruit. Now, obviously, the time at which it takes to get these things to trial plays into their hands with that a little bit.
Yeah.
Because delay for a developer, as I said, is a very costly process. And if
paying extra interest on all the money it's borrowed.
Exactly. So if you're faced with a potential litigation which could take 12, 18 months to get to trial, and your site is effectively stymied until that time that happens. I mean, you may decide to proceed at risk.
Yes.
Then you've got to weigh up, well, actually, that's going to cost me X amount of money. They're asking for Y amount of money. I'll just settle.
Yeah.
So the delay is a big factor, I think, in forcing it. But in terms of what is the appropriate level of damage, or should it get to that point, should the judge decide that, it is a release fee kind of scenario, or is it 5% or 40%? I think that very much depends on the specifics of the case, particularly the behaviour of the parties, which is noted in many cases, and how have they conducted themselves up to that point. But also, as was said in Beaumont, and I'll just read, what was said on the conclusion of the law, is that accordingly, I conclude to establish its claim in nuisance, Beaumont needs to provide that by virtue of the reduction in light, its premises have been made substantially less comfortable and convenient than before, which in practice means it must show, by virtue of the reduction, it is likely to suffer a loss of rental income over the balance of its 26 years in the amount which is more than trifling or de minimis. It is therefore irrelevant whether the premises were well lit within the definitions used by rights and light surveyors before the reduction in light was by Ferrara's works. So it's about, what is, they've got to be able to demonstrate they've suffered a loss.
In a commercial case.
Yeah. Now, obviously, residential would be different, but you'd still need to show that you suffered a loss.
Yes.
But it might be quantified in a different way.
Yes.
It's not a loss of amenity, a loss of enjoyment.
Yes.
But to just to say there's been a reduction in light, but I haven't actually suffered as a result, well, then there's no need for a remedy.
No.
So the two things must go hand in hand. And I think this is where the law is constantly trying to work out.
Yes, that balance.
Where that place
balance of justice. Just finally, Jerome, on Part 35 expert evidence, can have a scenario where an expert's involved early on in a case, and then there's a perception that they won't be able to give independent evidence because they're credibility, their independence might be slightly questioned if they've got, say, skin in the game. It's a dreadful phrase, but have had an involvement. Obviously, you were involved at the earlier stages in the Beaumont case for your client, and you also gave expert evidence, which, as I say, was accepted by the trial judge. So on the other side, there was sort of more of a movement of different rights to light surveyors through the process, because the judge goes into the facts at some length. How do you see that, and how do you find that?
I at no stage ever felt that there was any position where I felt conflicted or uncomfortable in my position. The surveyor is there to give factual advice to his client and to ideally try and resolve any disputes with neighbours before it gets to litigation.
Yes.
In that case, it wasn't possible to do so for reasons which are all well documented. But I never felt that there was any kind of issue at all in being the surveyor that had been there throughout the whole process. In fact, if anything, I thought it was exceptionally beneficial to be able to speak with full knowledge on actually this is what's happened here.
Yes. Takeaway points. I don't think we're going to run out of time for questions, Jerome. So what I'm going to say is that I'm afraid that we'll pick up any questions. You're happy to receive emails. I'm happy to receive emails.
Yes.
I'm afraid I haven't kept my eye on the clock. In terms of takeaway points, I think I will go first, if I may, very quickly. It can be a freehold or a leasehold property that can be injured. You're going to need a rights to light surveyor and a valuer, I think, in litigation to really value the losses. And injunctions may well still be granted even after building's been completed. I think those are the sort of three takeaway points that I would like to articulate about you.
Well, I think from the surveying side, I think really trying to get to grips in this modern world or this current world, what is adequate light? The basis of adequate light is old and science questionable. What is considered to be an actual nuisance to that light, i.e. how much of it needs to be lost in order for a nuisance to be caused?
Yep.
Now that is not going to be a one size fits all.
No.
And finally, in relation to light obstruction notices, there has for a long time been the assumption that because only a year's interruption is necessary, you can serve the light obstruction notice as long as it is before the apertures have been there enjoying light for 19 years and a day. You would be able to stop them prescribing their right. And obviously, once they're 19 years and a day, the obstruction can't be there for a full year.
No.
To stop them acquiring. But there is now a body of quite significant legal opinion based upon what's in the Act, both Acts, which says that actually it's not 19 years, it's 18 years.
Right.
Because you need to allow the recipient time to object to the notice.
Right.
And that is set out in the Act. So, but that has not yet been in front of a judge, but we suspect it might be at some point too distant. So let's see what the
resolution of that thorny and knotty problem. Jerome, thank you very much indeed. Thank you to our audience. I do apologise that we haven't managed to get to the Q&A, but we have finished it. We'll pick up the three questions and seek to answer them by email. And if anybody wishes to raise a question that they haven't had the opportunity to raise, and we're happy to receive emails and seek to answer legal or technical questions on an informal basis.
Yes, thank you all very much indeed. I do have your three questions here. We will respond to them. And yes, Clive said, very happy to take any by email, phone, anytime. Thank you.
Thank you very much.